Hey, good evening. Good Tuesday evening, everyone. So it's nice to see you here. Thank you to the mods that came, even though I scheduled a little bit late. Thank you very much. I appreciate all of you that came. We've got a few interesting things to talk about today. As you saw in the thumbnail, perhaps, it's going to be about Jean Carroll's second lawsuit, which was actually the first civil lawsuit she filed against Donald J. Trump for defamation and abuse. And we're also going to talk about Bryan Kohberger. Um, Basically, it's a lot of legal stuff today. There are no verdicts, there's no trial yet. There's no back and forth from the attorneys, except for in writing, which I'm going to tell you about, which is a little bit lit today. But these two cases had quite a bit of activity, and they both have hearings coming up. They're all over the news. It's getting to be a bit much, so I figured I better do an update before it gets too far out of control. Yeah. So thank you all. Let's just there is a poll though. I did want to say I've got a couple of polls I'm going to run today, and the first one is up there. I'm very interested to see if you all would like to hear about how I am following Scientology, another Scientology case, another lawsuit against Scientology. This one filed by Leah Remini for her years and years and years. She's just tired of it. Um she's gonna legally wrangle with them now, back and forth. And also there is another lawsuit, a case one of the Jane Does had filed. Um I only say that it was one of the Jane Does now because it was already outed that it was one of them, but there is a case against Scientology for things that happened to her as a minor. And I don't know if you want to follow that too, but when it comes to Scientology, I am interested not only because it's a cult, and yes, I am a bit biased. I think that cult is damaging. I really do. But also because the legal part of it, the way Scientology fights legally, going back and forth between legal precedent, this, that, the mighty dollar, and also trying to use church protections wherever they can, makes it quite an interesting case to follow, makes the rules a little bit different, um, as we saw in the Masterson case. When they didn't want their own book, they wanted to be treated as get all the benefits of a religion, but not have us say that there were religious contracts or agreements or beliefs that could be used by the prosecution. Um, there was a lot of double standard going on and a lot of legal stuff going back and forth that was, for me, fascinating. So I would like to know how you guys feel about it, because the last thing I want to do is come out here and bore you. I like to read this stuff in the morning. It doesn't mean you do. Okay. Not that I'll be out here reading it, but you know what I mean. If it's not interesting, then I'll keep it to myself for my own enjoyment. Welcome, KCG and Tony. I see you just came in. Hey, Juju. I'm not typing right now because you'll be able to hear it on the mic, but I see you all. Hello. Um, and let's get started. I'm gonna leave it up to you guys. Could you just put in the chat? Let's see, 1 for Carroll or 2 for Kohberger. Who you want to start with? Because I've got them both ready, and they're about equal in stuff. How do you want to go today first? Let's just say 1 for Carroll. Okay, so we have 1-1. Don't let Juju be the only one voting, everyone. Okay, she'll says Carroll too. I'll give you a moment. Let me just say, there's quite a few cases that I'm looking at. I'll just look back at the Rose Petal murders, um, and they do have an arrest, and but that case is just the whys of those cases, and is very confusing to me. What's going on there? I'll tell you. There's everybody's been arrested and all not for the murder, and then they did actually arrest a suspect on the murder too. But I can't see the connections. It's getting like a little crazy. So I think we're going to be all talking about that now. Fish Nerd, what's 7? Like, what are you voting for? I don't know what 7 is. Okay. Always Createful votes 1 or 2. Brain Bush. Okay. Okay. Yes. Always I agree with you. It's a mess. I'm just looking at it, scratching my head every day, you know. And also everything has kind of died down on Craig too, on the dentist murder, on the poisoning of his wife. We have that one still active too. We also have see a slowing down in the Stephen Smith case. In that investigation, I don't see any charges coming out lately. Um, oh, you stepped out for the answer, so you okay? So you know what? That's always the proper answer, Grace. 42. You're like me. That's it. 42 is the answer to everything. But actually, the question was, do you want to hear about Carroll, Jean Carroll's lawsuit with Donald Trump first, or do you want to hear on the Moscow victims, Bryan Kohberger? Yeah. Yeah, I haven't seen anything on Craig in weeks, nor the missing mysteries. Hmm. I wonder if I'm dying to find out if she turned evidence, if she gave an affidavit. I really am. I'm being super nosy about that one because it sounds a little juicy. You know, I can't imagine how she can kind of hold her head up, knowing while that woman was in the hospital, she was visiting that man in his own home. It takes all kind. Takes all kind, I guess. Yeah. Yes, I did sound a little judgmental. I guess I should apologize, but you'd have to actually be sorry for it to apologize. So sorry, not sorry. Mm, and That's what I felt. Hey, Mousy, how you doing? Good. Oh, okay. It's nice that you're listening, KCG. I'm glad. Okay, so it looks like quite a few of you are very interested in Scientology, so I really like that one. I'm gonna leave it up until I put the next one up, but it also looks like most of you want to go with Jean Carroll first. So let me get over to that one. So I'm ready. Okay. Sorry for that little bit of silence while I worked it out. Ooh. Okay. Let's see. Do I want to be here? I don't want to be down there. Eh, I don't know. Oh, that cuts it off. I better put it up there. Okay. All right. So Carroll versus Trump. Just a little refresher. These are defamation and assault cases. We had the first one has already been settled. Well, it's not the first one. First one, it went to trial, and was found guilty. And actually, this second civil case, which is actually the first civil case, which came after her 2019 interview, coming out with her book and saying that she was assaulted by Donald Trump. And then he went on a mass media thing and defamed her from all these podiums. The problem with the first case is that he did that while he was president of the United States. So when you file a civil suit like that, there is such a thing of a clause for immunity that we all know that the police and everyone uses in the performance of their duties to the government. You cannot civilly action them while that is going on. And it makes sense because you don't want to disrupt the process of running the United States, even if he is a bad man. Okay, and he does deserve the charges, and people should have a right to file them. You just can't do anything about it while he's sitting as president. Okay, so there was that. It went to the Supreme Court. It went back and forth. It went up the state Supreme Court, and then they kicked it to the higher Supreme Court, which kicked it back down to the state. And this was the premise they kicked it on. They were unable to determine by employment standards, in other words, the United States government being the employer of Donald J. Trump at the time, all of us, we the people, if actually when he was doing that, if that was under the guidelines of his employment, like his duties, so to speak. And it became a big bone of contention back and forth because Donald J. Trump filed motions in this lawsuit to have himself removed as the defendant and have the United States government be put in, because that is something you can do as president. Okay. And under these laws of protection. Well, that didn't go through. They said no, if anything, it would just have to wait till after. then we have to decide if he was actually if the words that he said were protected under him performing the duties of his office. Both courts decided, nah, not so much. Supreme Court decided, or federal court decided, the highest court decided that there wasn't enough information for them to make the decision, and they left it up to the state Supreme Court. Went back down to the state Supreme Court, and they decided that, well, although he may have been the president at the time, it seemed that you can actually conduct your personal business while being a president. You actually can do other things besides govern. And they decided that based on the statements that were made, that wasn't really operating under the umbrella of servicing the people, that it may have been personal, and they allowed the case to go forward, which is where we are now. Since prior to the filings that have recently happened, there was a guilty verdict in the second case he was, because once he found out that, oh, well, he had this thing, he waited when he wasn't president, and then he went out there and he started talking about her again. And he did that after he was president. And so the second filing that she did was the one for defamation for those statements made after his presidency. And also she added a charge of rape, because under the New York statute, as an adult survivor of something, based on the new statute of limitations lifting in a year window that was opened up for survivors to file claims, she pressed charges on this very old assault that she said happened in a department store, which she has a guilty verdict, but not of rape. There has to be clarification, and that's going to, and actually becomes a bone of contention in the filings that we're going to talk about. Okay, so the verdict came back in the first trial that started in May that he's guilty of sexual assault, because they could not, the legal definition in New York requires a penis. Sorry, it does. And there was no statements giving or evidence giving that said that he violated her with that. Although they did agree that she was violated against her will. They called it sexual battery, I believe, sexual assault. Okay. And still awarded her a good judgment. She got a $5 million judgment. Okay. Almost half for the defamation, and the other half for the emotional distress in the violation that occurred. They agreed it happened. And it's just not to the extent that the law needed it stated. So they had to downgrade it, but they still went through with it, right? Well, that seemed evident to everybody that read the verdict and went through. And several things happened after that. Number one, granted, there was definitely an appeal being done, but they just didn't appeal. They demanded a new trial. Okay. That demand for the new trial and everything and appeal has been already denied by the motions. There was not. The claims that were made by Trump's attorneys at the time were that it was an unjust jury verdict, that they didn't have enough information to go through, that they were something about the amount of money that went through that was too much, based on the fact that it wasn't, that they downgraded one of the charges. Okay. Still saying that they want the appeal based on the fact that they never should have went through in the first place. They're still going back to the original, even though it's already gone through both Supreme Courts and the judge. Okay. Several times they wanted it. Okay. So Trump and his team did try to appeal, did try to get the verdict tossed, did try to, is out there talking prejudicial by Judge Kaplan, saying, this, that, and the other thing he's working on, he's prejudicial, it's obviously politically motivated, the same old. You'll hear that a lot lately, because unfortunately, There are quite a few cases against Donald J. Trump right now, and every single one he says is a witch hunt. They're all for different things. I can't imagine it would be this coordinated by like half the free world, hmm, to file charges against him when it's really difficult to do. And you really got to dot your I's and cross your T's. And it took them years to do it. And these are only the 2016 campaign charges that first came through in New York. It took that long. Remember, he was president for a while. They wouldn't been in anyone's best interest to try to do that and upend everything. Not that anyone wants to put anyone above the law. That's not what it's about. It's about operating the country in a manner that might be conducive to getting anything done. Not that I'm saying anything got done, because God, I wouldn't say that with the way Congress is in the Senate right now. But I would say that you at least don't want to throw a monkey wrench into the works to make it worse. Okay. And yep, rabbits, I agree. Delay, delay, delay. But it didn't work. Kaplan shot it down. They're going to go to the Supreme Court with it. It's going to get shot down because if, when a judge issues a 59-page dismissal into why you can't have what you want, you better believe it's full of legal precedent that is preparing it for the Supreme Court so that they know where you were coming from. And that's what they're going to have to argue against. And that's not as easy as whine. Oh, no. Okay. Which, unfortunately, is all I get from these briefs by Trump attorneys. All I can say is, like, he's really... his defense is getting to the point with these attorneys that they're just, I don't know what the heck they're filing anymore. Okay. So true to what we've seen Donald J. Trump do in the past, as soon as this verdict came in, he went out and he disparaged her as a whack job on CNN after the guilty verdict. So she amended the charges to put new claims of defamation, not only the ones before when he was president, but that he's still doing it now after being convicted and told that you're going to have to do this. You're going to have to pay her some money, although he's appealing. He really does have some entitlement going on there as far as like he's not going to have to do anything. But this is getting to be too much. But anyway, he disparaged her because she went on a CNN interview and once said, well, they said that you weren't physically assaulted that way. She said, no matter how you slice it, he did. Oh, yes, he did. So because she said that on CNN, Trump and his lawyers then came forward with the great idea that because she said that she was ARD, okay, she was raped. She claims I was raped. The law states it had to be by something, but it still was a violation. I was penetrated. I was against my will. That's the word I use. And she's sticking to it. Well, he decides to countersue her for defamation for using the R word because the jury came back with sexual assault instead because it was digital. Well, I was rather amused to read in Judge Kaplan's response to this counterclaim. First of all, I'll tell you, you see that word dismissed? Oh, yeah, it's tossed. Trump cannot sue Jean Carroll for that statement. Judge tossed it right out. Tossed it out. And he took a while to do it, too. He listed everything. And what he did list is one of these statements that I want to show you guys right away. First, let me introduce you. Judge Lewis Kaplan, okay, since we're going through the pictures. And he's been doing some opinion, and he's been writing really lengthy opinion and stating, precedent and cause in everything that he's doing. He is dotting the I's and crossing the T's so things don't get overturned, which is why I do not think the verdict in the first trial or the monetary amounts will get overturned, even if it does go up to the Supreme Court. Alina Habba is the attorney of record in her law firm for Donald J. Trump for this case, although during the trial, she was not there. most of the time. She is the one on record, though. It's her law firm. Roberta Kaplan is Jean Carroll's attorney, and she did a bang up job in the first one, and she's listed in this one also. So let's just get here. Okay. The reason for the not going through with the verdict, Kaplan just said the jury in this case did not reach a seriously erroneous result. Its verdict is not a miscarriage of justice. Mr. Trump's motion for a new trial on damages or a remitter is denied. I have considered Mr. Trump's other arguments and found them all unpersuasive. Attorneys don't like to see that. That's not a good look for an attorney. Hey, Maya, nice to see you. Just definitely not a good look at all. Hey, West Side Girl Reacts. It's good to see you too. Thanks for joining us and everyone who's coming in. All right. So that was on the dismissal of the appeal and request for a new trial. Okay, so now, one more. Now, in the case where he is asking actually to sue her, okay, this is right from what Kaplan had wrote. Unlike the jury's finding on the penal law rape question, its finding on the sexual battery, against whom estoppel is invoked, had a full and fair opportunity to contest that issue in the previous litigation. In other words, while they were in trial. Okay, and specifically, its implicit determination that Mr. Trump digitally raped her is conclusive with respect to this case. As a result, Ms. Carroll's statements are substantially true, as ordered by the court. Can't be sued for defamation if your statement is substantially true. Okay, so because the penal law code is written a certain way, and this is something that I talk about a lot, because it does need to be clarified from state to state, and it has to be more encompassing. Because I mean, I understand where they're coming from semantically, okay, but in regards to what actually rape is, doesn't matter what they used. Okay, it's seriously. Okay, the definition needs to be broadened. It also needs to encompass the opposite sex. Okay, because it happens there too. We shouldn't need 3,000 different laws for the same thing. This one, these penal codes, state by state, need to be looked at in this aspect. Okay, the same thing with the consent laws and the statute of limitation laws for certain offenses, especially on abuse. Okay. Well, I was glad to see that Kaplan was being very common sense and actually quoting back the exact verdict from the jury. They said he did it, but the penal code did not substantiate the word, so they had to change the word. Okay. All right. Let me just go back to just me for a second because I don't want to talk about that part yet. Okay, so in regards to the rest of the things that need to be covered on there, like not only was the counterclaim filed in, it's been tossed. Okay, he also did it with his attorneys. The defense filed a motion to stay. In other words, they wanted nothing to go forward to say that he was going to be running for president. If they needed time, and they wanted their appeal to go through first on the first part of the case for the ones that he was just found guilty of. They wanted all that resolved first, and then they were trying to advocate to stay everything, just halt the process, But Jean Carroll has to agree with that, and so the attorneys and so does the judge, and they all decided, nope, we got to go forward. They're keeping that trial date of January 15th, 2024, because as Judge Kaplan put in his ruling, since most of the case is already settled, except for the swapping out of certain statements, all has been done. Okay, it's just a matter of when you said them. You still said them. You continued to say it, and like he added more after the first verdict. There you go. Judge says, nope, we're not staying. So then they said, okay, if you won't stay it, how about we just get rid of it? We're going to dismiss it. Nope, that's gone too. And that was a long one too, because they just rattled on about, this was a witch hunt. This was over prosecution for the same thing, but he keeps doing the defamation. Okay. He keeps doing the defamation. Okay. Now, in this one, because they've already said that he did violate her against her will, she don't have to prove that again. And that proves that the statements that he's saying are false, which means the accusations against her for lying and being a witch hunt do fall under defamation. In that light, this should be a very quick trial. A very quick trial. All of the evidence has been substantiated by a verdict already. And that's it. Okay. Now, the plaintiff is now, all right, so let me get to that part now. The plaintiff actually filed for a summary judgment, a partial summary judgment. Okay. And what it is like she's trying to speed up the process. Let's just let me just put this one back up. Okay. And for in doing that, what she's trying to do is just save some time. Because like I just said, if they've already put down that the event, the violation occurred, okay, that she is talking about, that he is claiming is defamation, but she is claiming it's true, and then he goes out there and starts slandering her and saying all of these awful things. Um, if they've already proven the fact that the statements are on, okay, and they've already proven that he said it, it's all in writing and it's already been submitted. He's already been guilty of it once. They only have to prove those tweets exist and that he said it, and he actually did it on CNN live, like right after the verdict. So I really think that this would be pretty quick. So there's going to, she smartly, Kaplan, Roberta Kaplan and Jean Carroll, they've decided to go for summary judgment, a partial summary judgment. So it states that, please take notice that the plaintiff, Jean Carroll, hereby moves this court before the Honorable Louis A. Kaplan, United States District Judge for the Southern District of New York, located at 500 Pearl Street, New York, on the date set forth by the court for an order declaring the specific issues enumerated in Section 1B of Carroll's Memorandum of Law to be subject to the doctrine of preclusion in Carroll 1, based on the jury trial verdict in Carroll 2, and granting partial summary judgment to Carroll on her defamation claim in this action as set forth in Section 2 of her Memorandum of Law. In order, it basically says, could you please use all of the testimony we submitted and the declarations from prior, and what we have agreed based on the court is actually the truth and the facts in other opinions, that we can go forward and ask for summary judgment and be done with this. The motion is supported by an annexed memorandum of law, plaintiff's statement of undisputed material facts pursuant to Local Civil Rule 56, and the declaration of Roberts A. Kaplan in accompanying exhibits. Now, they're saying that since the judge has ordered in such a way several times to say the event has already occurred, you can't do appeal. You can't get the case tossed out because this is what you did. You can't countersue her because of the wording. All of these statements they want put in, and all of them lead to perhaps being a much quicker trial because they only have to just get it on record and do a judgment for the amount. Okay, now that doesn't mean he can't appeal. And they do need to do motions. The defense, of course, Trump and Alina Hobbs' legal team, or whoever he has working this one now, I'm not actually sure yet until the next filing comes through. I mean, they all have Alina Hobbs' letterhead on it, but she's the sanctioned attorney, and she's been doing press and PR for him. But she was not in court for the first trial. We didn't see her. So I didn't see her that often. All right. So I'm not sure. We'll clarify that. hopefully by the next time we talk about this. But in doing the summary judgment, which the judge has some time to think about this, I mean, he's going to keep going forward with it, and just he's going to do legal precedent, and the way he's been doing his opinions are very documented and ready, because he doesn't really want to waste a lot of time with appeals and overturns. He wants to give them all of the information to know where he's coming from. Makes it easier for everybody involved. And I will say that you do not find a lot of that in a Trump response, or a Trump lawyer response, I would say. Most of them are done by letter or education in sometimes I wonder if they're talking about the same thing, to tell you the truth. And I don't mean that to be so snarky. It's true. Like, I read them and I'm like, well, this doesn't have anything to do with that. Like, where's this coming from? It's like they throw everything out there that they can. And I can understand why. There's a lot of cases going on, and he just wants time, time, time. It seems like in all of the Trump cases, what he actually wants is time. He wants to be able to be president again. Okay. The problem is, with federal cases, he can do something. Okay. With state cases, he can't get verdicts tossed or do pardons. He just can't. Okay. Okay. So let me just pull this down for a minute. I'm going to check the poll, because I have another poll I want to put up for you. Okay. Now, I know talking about Donald J. Trump isn't pleasant for a lot of us. Okay. And it does bring a lot, a lot of turmoil back and forth and difference of opinion. But there are quite a few other cases. And so I am going to put up a poll to see if tomorrow you guys want a review of the other cases still. They are pretty active now. And this includes the ones that he files, Like, be fair. Like, I did have this one that he filed against her on the roster, but it got dismissed before I could actually bring it to you. So let's just, sorry for the clicking. There you go. And this would be for tomorrow, actually, because I have time in the afternoon. Here we go. Okay, did that pop up for you guys? Yeah. Hey, Mrs. Cassandra, nice to see you. Maya, it's good to see you. Hey, Mippet. Peter, nice to see you too. Okay. Let me just see if there's any questions before I go on this. All right. Juju, do civil cases have to be jury, or can it be a bench trial? I think when it comes to summary judgments and all, is up to the judge. And I'll have to look. I do think you can ask for it, but it's most often a jury trial. Okay, because in civil, it's not criminal. Very often, somebody's not going to jail in a civil case. It's monetary. It's what we call a justice case. It's just because there's been injury done, and you want it on the books that somebody did something to you, and you want them to pay. Does that make sense? Like, yeah. And so they usually are a jury. Okay. The actual evidence load is lighter. You're allowed a little more speculation. It's not without a reasonable doubt. It's, can you reasonably confer? Does that make sense? Like, that's where you go with it. Hey, Verillion. Will Trump be required to appear this time, seeing as he didn't get the message the first time? I don't think in civil cases, there's always the option of the defendant. They have the right, of course, but in a civil case, he can appear, he can ask not to. In a criminal case, the judge can order you to appear so that you can't get it tossed later, because you have to face your accusers. There's a stricter there's stricter ruling there. Remember, in the Letitia Storch case, she didn't want to show up, and finally, like, he just kept making her. He kept bringing her. And then Lori Vallow didn't want to be present when they did the evidence on what happened to her children, and the judge made her stay there. Okay. He let her go out for a little bit to get some fresh air, but she had to come back. Um, because in a criminal case, you have to be, it is actually very hard coded into the penal code. You need to be there to face your accusers. It also so that you can contest anything too. They don't want any loopholes, you know. Hey, Peter. Okay. Let me see what else we have. Those are good questions, by the way, guys. Thanks. Hey, Mary Beth. Nice that you'd be here. Let me see. Yeah, Juju, it does. I agree with you that the legal definition needs to be broadened. It makes it difficult, especially you could see in a case like this. Now, this was a civil case, not a criminal case. Can you imagine if it was a criminal case? That would be the difference between real penal code being applied, like years, and probation. It's serious when it's a criminal case. Okay, yeah. And not that it wasn't serious for her to get her judgment, but still. Yes, a quick trial is a good trial. I agree, Mipit. I think that because everything's been laid out with precedent, it's only prudent to just get it over with and just go. I can't imagine with the same evidence and everything, somebody's going to just do the opposite. That's not going to happen. The points of law have all been proved and documented very well by Judge Kaplan, which is why Jean Carroll's team felt very confident in going forward for a preliminary summation, and just like have the judge look at it, decide, okay, here we go. The sticky part was because he was in service to the country at the time of the first defamation claim. Wasn't allowed in the criminal case? That defamation case shouldn't be brought forward. Not in this one that I'm aware of. I do not believe there was that in this one. I think we're speaking about a different case, and I think I know the one you're talking about. I'm going to check into that. Trump will do what Trump will do. The man does whatever he wants. Yes, and what he wants is time. Yep. Hi, Fangirl98. You've been on JL's channel? I like JL, and I do stuff with him on Thursdays. We do the challenge, and welcome. Welcome. Pragmatic, it's nice to see you. Hey, Wrecker. Nice of you to stop in too. Okay. So I'm glad. Okay, so everybody's got their. All right. I think I welcomed anyone I forgot or I missed you in the chat. It's not intentional, I promise. I'm just trying to get on to the next one. If there are no more questions in regards to the Trump Carroll case, which is going forward right now, there will be another hearing, I'm sure, or at least a motion on this summary, and there could be a hearing, brief trial to go forward. Maybe it'll get moved up, who knows? But it's for January of 2024. Although Trump's team does seem very adamant on trying to get that delayed. They're doing it in all the cases, but right now, it is still on for January 15th of 2024. New York does not allow cameras. We won't see it, but we will hear all about it. It was a big case, the first one, and we got the news right away. So we'll know right away what's going on. Okay. For this, he can't get time in prison, Peter Noddle, but there are so many other cases, which it looks like by 76%, although no one likes the name Trump, it looks like we will be talking about some more Trump legal cases tomorrow, and those do have prison time allocated towards them if found guilty. The charges are quite severe on some of them, and we'll talk about some more coming down the pike. Actually, I heard some rumors about Georgia coming through next week, but we'll see. And we've already got three indictments going. All right, so let me get back. So I think we're going to move on to Bryan. It's Bryan Kohberger. Just bringing this up again. All right, here we go. So Our second one was Bryan. Okay, now we know that Bryan Kohberger is charged with first-degree murder and burglary in the deaths of the 4 Idaho University students. Okay, we know that he's going to be going for the death penalty. There is currently a gag order in place, and we all saw the media frenzy in the beginning that led to this gag order. And I think I've spoke on it before. I do think that it's necessary in some way based on some of the reporting I saw, and basically it's involved all people in law enforcement. It does allow the families to come forward and talk. It doesn't limit them, but it does limit the amount of information law enforcement and the prosecution and the defense is allowed to talk about in regards to the case when it comes out here. All right. There was a discovery deadline on July 14th, partially met. Okay, partially met. And I left that there, not because I forgot to change it, but because I wanted to remind myself to talk about the going backs and forth between Ann Taylor and Bill Thompson's office right now, who is the prosecutor in Latah County, in Idaho. He actually uh they are giving them information back and forth, but there have been some filings. Like there's certain information he doesn't want to give out yet. And there's been some pushback on quite a few things. Okay. Um the trial is still set for October 2nd in 2023. But there are so many motions out right now. Like when we get to this other part, there's a motion hearing coming up in 10 days. But actually, to try to report to you what happened to all those motions without you knowing that they're all coming up, there's like so many of them. We have to do this before they do that, just so we could briefly get through once they finally decide what they're going to do with all these motions. There's that many of them. It's getting crazy. Okay. If you've been following every day there's a little piece of news coming out, it just really is getting crazy. But in regards to the motion hearing for August 18th, these are just the defendant's motions that have to be heard. Defendant's third motion to compel filed January 22nd. That third motion to compel is the release of discovery, certain particular items that they want. They were arguing back and forth on training records for everyone involved. When the prosecution said, well, you can have the training records on the 2 lead people that are involved, but for everybody in the whole thing, like, no, that's ridiculous. We're going to be here for like 20 years. And it's just going back and forth with things like that, back and forth. Defendant's second motion to stay proceedings filed on July 25th. They filed that at the end of the month. They want to stay. They want to move that trial from October 2nd. They actually want to stay all forward proceedings because they've also filed a motion to dismiss based on grounds of error in grand jury instruction or in the alternative remand for preliminary hearing filed on July 25th. If you recall, we were scheduled for a preliminary hearing, or though we thought that was the next step for Bryan Kohberger after he was arrested and he was brought in for arraignment. He didn't enter his plea. His plea was entered, he had time to do that. He got his defense attorney, Ann Taylor, and then during this process of discovery and everything that was going on, Bill Thompson's office, the prosecution, went to the grand jury instead of doing a preliminary hearing. In other words, you can go to a grand jury with enough evidence to say, do I have enough to go forward here? I think I've got a case and it's like a slam dunk and I just want to do it. The other way is a preliminary hearing where you do present all the evidence with the defense there. Now, this is the difference. With the defense there to hear it all, see it all, and to see what goes in and what goes out in front of the judge to see if there's enough to go forward and set a trial date. All right. Now, Kohberger is remanded to custody while all of this goes on. So, they're going over the process, why it happened, what the jury instruction was. They're using a term that changes the whole course of what the judge would be doing in this case. So I can't really get into the nuts and bolts of that until I see where the judge is going from that. But I can't wait to see how that gets answered. Because to me, some of the things that the defense is doing, although the legal terms are all there, you're wondering why in this case this kind of stuff is being done if he's innocent. And I know he wants to prove he's innocent. And Until he's convicted, he is. Yes? Okay? He's just alleged to have done all this. Okay. Now, as we go forward, the defendants have already said that they received thousands and thousands and thousands of files in regards to the evidence, and it's so much to go through. So as they're saying they don't have everything they need, they're also saying they have so much to go through, they need the state, they need delays, okay, to be able to deal with it all. So it's kind of like going back and forth with the prosecution at that point. Okay. Now the prosecution, the state, um William Thompson's office, the state motion for a protective order filed on June 16th. They want all of the evidence protected and sealed. Okay. And their motion to reconsider order of staying time for a speedy trial filed on July 17th. In other words, they want to go forward. They're ready. Okay. State's motion for a scheduling order was also filed on July 17th. Now, what's not mentioned here is some of the other crazy stuff that was going on. But first, I want to remind you of who are the victims for this case against Bryan Kohberger. He is being accused of killing the 4 university students all in one home. Ethan Chapin, Madison Morgan, Xana Cornoldo, Kaylee Gonsalves, all very young, and we don't want to forget them. We want Bryan to get justice too and be tried fairly and have an opportunity to defend himself. We want the legal system to work properly. Well, since there are victims in this case, we want to make sure that we don't forget them either. And then the protective orders that have been already, the gag order that is in place, the judge has come out clearly, Judge. And yes, that is his name, Judge. Actually came out clearly and said he's not preventing, especially the Gonsalves family, from speaking out. It does prohibit the amount of information law enforcement can go going forth, but law enforcement did come forward, as did the prosecutor's office. They said that they do meet with the families, okay, and that it's just a matter of scheduling and meeting with them. They're not keeping information from them, but it has to be done in a certain manner. And I kind of understand that. I do understand the family's frustrations too. It's been a bone of contention. They've been speaking quite loudly about it. But in order to get justice, sometimes that's it. I understand that they feel they need to keep an eye on it to make sure there's justice. Currently, they have no faith in the system as it is, because as soon as someone is arrested, you are alleged crimes and you are innocent until proven guilty. So there are a lot of protections to that person. And if you are a relative or a family or someone who loved one of the victims, it might be hard to take. But that's how our system works. And I understand the process, and everybody is upset about it. Well, I think this judge probably thought far enough ahead to prevent an even bigger problem, that if it was all out in the media all the time, you have to understand it gives people a lot to appeal with. It gets into the case, it affects the case, okay, in all kinds of ways, in an uncontrolled manner, which we don't want, because we want due process to go through, efficiently, in hopefully speedily. Not often the case as far as speed, but at least efficiently and accurately. That would be good. This is Judge John Judge. Yes, that's his name. And he's been ridiculed for the way he speaks. He mispronounced several of the victims' names in the beginning, and I feel for him because I did the same thing, not out of disrespect, and I won't even come up with any excuse like he did about food poisoning and things like that. Like, I just mispronounced it. It happens. It wasn't done on purpose. He should have just went with that because there are quite a few memes. Anyway, this is William Bill Thompson Jr. He is the lead prosecutor for Latake County in Idaho, in Moscow, Idaho. And this is Ann Taylor. This is Bryan Kohberger's attorney. Okay, so questions in regards to those motions or anything, I can only go into so much in details about that. But I, what I will say is that in regards to this case, there's a lot going back and forth about a certain amount of DNA. Because it was such a small amount of DNA that there's actually in what we would call their presentation of alibi, which I do want to talk about for a few minutes before we finish up. Okay, the defense. Okay, first, the prosecution said if you're going to come up with an alibi in your defense, you need to make your alibi motion. You need to put it forward and with your witnesses. So they did a motion to compel them, the defense, to come forward. When the defense filed it, it became quite a thing in the media and everywhere because it's talked about quite a lot. Because all they basically said is that, well, Bryan Kohberger likes to take drives at night alone, and he wasn't there because he was off driving alone by himself. And we will question other witnesses to prove this, but they wouldn't give the list of witnesses that they would be bringing forward to prove the alibi. Okay. So then also in this letter, which was the presumed alibi, was also the claim that the DNA may have been planted. It's on the knife sheath, that drop that they found. There's some confusion going back and forth, but because we don't have open files here, we're not able to see exactly what they're talking about when they say it. Okay, but okay, when they released that alibi, court filing, said that he was out driving while they were murdered and he couldn't have done it. Okay, but there was someone in the house who was saying that someone fitting his description was there. That may or may not be enough. It's going to depend on the jury and how the evidence is presented. Okay. And Taylor stated that in this that he's got a long habit of going for drives alone. That's what he was doing. Okay. That he would drive at night, and he was driving at night on November 12th and into the 13th. And he's not claiming to be at a specific location at a specific time. Now, here's where the prosecution has a problem, because to claim an alibi, you need to claim to be at a specific location at a specific time so that it can be corroborated, because an alibi is not good without corroboration, correct? I mean, it's just not going to stand up. You can say whatever you want, but who's going to say along with you, or what facts are going to be added to it to say that, yeah, that's where you were? Okay. Is there CCTV camera? Is there an audio recording? Is there a pinging from your phone to an exact location? Is there a phone call where we can hear something in the background that might pinpoint it, like if you were at a game or a concert or sitting in a bar with a TV playing at a certain time, something like that. All right. There's not a specific witness, she said, to say precisely where Mr. Kohberger was at each moment of the hours between late November 12, 2022 and early morning November 13th. That he was out driving during the late night and early morning hours. That's all the filing state in regards to that. Corroboration of Bryan Kohberger not being at 11/20/20 King may be brought out through the cross-examination of the state's witnesses. At this time, Mr. Kohberger cannot be more specific about the possible witnesses and exactly what they will say. The defense has been hampered by the state's own choices, in other words, going to the grand jury. And because they didn't have a preliminary hearing, they don't have the list. They don't have all of the statements that they're going to be coming forward. They don't have it. Okay. If the state had proven, and this is what she says in her alibi statement for Mr. Kohberger, if the state had chosen to move forward with a preliminary hearing, the defense would have had the opportunity to develop testimony through cross-examination and witness presentation. Okay, this is just what they are trying to do is keep open the prospect of creating or generating an alibi should they find information while going through the evidence to do so. because this is not an alibi filing. No one who has seen this, who has much more legal experience than I do, nobody on LawTube, okay, nobody that I know privately that I speak to, not any of the paralegals, not any of not any of the attorneys, not anyone commenting on it, would agree that that was an alibi statement. You just can't actually put that forward to the court to say, I was just driving around, and have it be a legitimate alibi statement. It's not. And of course, the state is a little perturbed about it. Okay. What the defense is really just grasping at straws, apparently. They're just wanting to keep a tight case, their case tight to the vest. And try to put prejudicial slanting on the state. It does appear like that. Okay. He was indicted on May 17th, and he's been arrested since. He was extradited from Pennsylvania to his parents' home, and he's been in lockup since awaiting his trial. Okay. It just doesn't when it I don't understand why put that forward if it's not even it's not even it I don't understand the purpose. Do any of you see like why? I mean, am I missing something? Okay. Um The other thing that they were complaining about in the filings was that the DNA and evidence that was taken from the knife sheet at the crime scene showed a statistical match with a cheek swab that was taken directly from Bryan Kohberger after his arrest. Now, that is in the court filings, okay? And they're actually going against that, okay? But they are saying that that could have been planted. It's a statistical match. They're wanting more details on it. They said that there was at least 5 times more likely to be Kohberger's DNA than a random individual. That's a lot. Statistically, that's a huge number. And statistically, it falls into the realm of being positive, you know, of being a positive match. Now, is there a lot? No, there's really not. Now, that was all going back and forth in filings all through June. Uh, but it looks like so far that DNA evidence is going to stay in for now. Okay. They haven't got to the part where they start kicking evidence out because, like I said, they're still going for delay after delay. The state just recently filed again for the defense to come forward with an actual alibi, or that's going to have to be pulled as the alibi statement. It's not. Okay. It's just not an alibi. Okay, they need to list the witnesses and they need how they're going to prove it. But it seems they're going back and forth in regards to the evidence because Ann Taylor does not feel, as the defense, that if the prosecution isn't going to release everything, that she doesn't need to either, that they're hampering her case. And the judge has a very big decision here because he has to decide if she needs all of that information to actually get a good defense ready for Bryan Kohberger. You don't want to be perceived as not giving them the information. Now, they have been giving it all to them, and now they say they need time to go through it. Okay. That's the thing, it takes time when you ask for all of that stuff. And then they ask for more, but it looks like it's just a staying procedure. It's just like to keep things tied up a little bit. I think this processing of the alibi statement is also because you get time to reply, time to push back. Now there's another motion from the state. It kind of delays everything. But we're looking at a trial for October 2nd, right? October 2nd of 2023. It's just around the corner. They really should stop playing footsie like this and really get down to the nitty gritty. Because we need to make sure that we've got all our ducks in a row before we go forward. Okay. I'm going to take some questions. Rabbits. That's a terrible alibi, but it's still one. Don't know how it will hold up in court. Yeah, it's an uncollaborated one. And they are pushing back. Actually, they just want witnesses, or have them say. But to say that their witnesses would actually be the testimony of the witnesses that the prosecution brings forward, that basically they're just going to query them and tear their testimony apart. I mean, it's possible, I guess. It just didn't go over very well with the judge or with the prosecution. Yeah, I don't know if he was out playing Pokemon Go or not, Fishner. Yeah. I'm surprised he wasn't the DoorDash driver. Nope, that's been documented that he's not. There was speculation in the beginning, but nope. That DoorDash driver came through with the receipts. Everything is totally in the clear. I do admittedly put my phone on airplane mode and forget about it unfairly. So, oh, so if he was charging his phone, he could have not had any pings in the area if he was charging his phone. Or maybe he likes to drive in quiet. hmm Did he usually turn off his phone? He could have, but they did find pings. Remember, we have the other evidence from the indictment, which I gave all links in a prior video, but I'll relink down here for you because it's coming up. In there are phone pings, tower pings rather, not except phone, and also showing of a vehicle very much like his. Uh, they are claiming to be his in the area. Yep. The Honorable Triple J. Yes. Judge John Judge. Yes, the judge's name is spelled like judge. So it actually is. Yep. Both sides are doing a good job because I don't know what to think about Kohberger. I don't either, actually, Juju. I'd have to say that to me, the evidence is not compelling enough to convince me that that is absolutely the murderer. Although, does he fit a profile? Yes. Does it have all those juicy things like his criminology degree and his fascination with law and all this other stuff? Sure. But that's not a reason to convict somebody. Okay. Is he trying very hard to get a good trial? Yeah. Mm-hmm. They are. And I think he's working with his attorney well. I think she's doing a good job and doing everything that she can to make sure he gets a fair trial. And it's a very big trial as far as the media is concerned. So there's a lot of pressure. There's a lot of pressure on the judge to make sure that things are fair, that things aren't leaked, that things aren't being presented in a prejudicial light. Right now, the defense is actually pushing hard on the prosecution and trying to actually tear apart uh, the reputation almost of how they are handling this case. And you can see it. But, this happens, they're pushing back too. Okay. Well, it's going to be just wrangling back and forth, but really, right now, there's not a lot of time. And I really hope it doesn't get delayed. I do. I wonder if he was caught on Ring doorbell arriving home that evening. He has an apartment near another university. Okay. If he had a strong alibi, then they would have to put it out there, wouldn't they? He was at McDonald's at 4:30 getting a coffee. Exactly, because a lot of McDonald's do have cameras and stuff, but apparently he wasn't, and he doesn't have a strong alibi, and that's the problem. So you can't say you've got an alibi and then not provide one. I want it to be him so the person has been apprehended, but I'm not convinced at all. I feel pretty much the same way. I really want to see the case proceed and actually see what evidence they put out and how it is the defense can go against it. This alibi just made my stomach hurt, though. To like, why even put that out? You know, I'll tell you what. Yeah, maybe a judge in the front and a judge in the back. We all do, Jujubee. Law enforcement is not allowed to put the case out here. All we have is the indictment. which went to the grand jury and did list a lot of the evidence. We know about the DNA, the small drop that was found only on the sheath, no murder weapon. But here's what they don't have, and we've talked about this before. What they don't have is any other DNA on Bryan Kohberger at his parents' house, in his vehicle, anywhere, anywhere, in his apartment. They searched everything. And no matter how fastidious you are, how much you clean up, something would be somewhere. There is no evidence of the crime anywhere in his personal belongings and everything around. So that came forward. That stuck out to me, what we don't see. Sometimes it's what we don't have, you know. Really, maybe that alibi is all they have. Yes, maybe it is because he wasn't home. And if he was, he lives alone anyway. We'd have to see. I mean, he didn't have a class. There, like it was the middle of the night. He wasn't at any of those parties. Like, you know, what would you do? What would you or I or anyone do if convicted, if accused of a crime right now? And this is where you are. This is where you are right now. What are you doing? How are you going to collaborate what you're doing right now as an alibi in a court case? Ha, homework. Look at that. Anyway, well, really, think about it. I mean, I'd have a hard time. There's nobody here. Well, actually, I'd have a better time because it would be documented on YouTube that I was right here speaking to you by live mode, right? And then you guys in the chat, will there be documentation that you were actually here? Or at least someone using your account was, because a good defense attorney or a good prosecuting attorney would try to prove whether it was actually you or not, you know. But me, my voice will probably carry forward, and it'll be hard to say I wasn't here, right? Hmm? Well, yeah, we're still going, Rocket Couch. I'm just finishing up. Nope, there was nothing in the car, Jujubee. And to me, that kind of speaks loudly. I don't know about you. Yep, how are they going to prove it without DNA? All they have is a drop on the knife sheath, and they did swatch magic to a statistical match to Bryan Kohberger based on a cheek swab from him. Juju, that's a good one too. I would ask my nosy neighbor to verify I arrived home at the start of the stream. There you go. The car revelation was shocking to me. Yes, you see, the car, there are pictures of a car very much like his, okay? And they did find a car just like it. He did change the plates, but it was normal. It was time for his registration anyway, and he had moved over closer to university across state lines, so he had to re-register. I get all that. Like that was all normal. Okay, but the fact that they think that they've got the car going in different, like around the house several times, more than just the day of, the next day and the day before, and even before that, they do believe it is that car. So this is your stream. This is your alibi, rabbits. My alibi is I was watching Clairview stream or messing around in Mallory's place. Bulletproof alibi. Exactly. Witnesses everywhere. There was a YouTuber that falsifies the live stream as an alibi. Was there? Peter, tell me about this. What case is that? I'd be interested. Hello, Paula. It's good to see you. Need more about the nosy neighbor. I mean, how nosy is that neighbor, right? Another guy in my city drives the same car as me. But yeah, but sometimes you can pick up partial license plate numbers. I'm hoping they have more. I really do. Okay. But yeah, now I got you all thinking about alibis. But you see how it goes, right? Like it could be either way. And it does look like you do want to hear about Trump tomorrow a little bit. So I will schedule that. That's the last poll on there for the day. Looks like more than half of you. The other half, that's what it's going to be about. But if you look at my thumbnails, they usually pretty much tell you what we're going to be talking about or the description. So there we go. What if you're the nosy neighbor? Well, then you know everything that's going on and when it was going on, and that's an alibi in itself. Like you could say that, Mrs. Jones was watching this on at this time, and that would say that you saw it. Like, and you saw her doing it, what she was wearing. That would prove that you were where you were. So I guess being the nosy neighbor is gonna help, you know. Rocky Couch. I'm also curious about the falsified live stream thing. I asked because I had a similar idea once. Yeah, Peter, I'm quite interested. So if you have anything, my DMs are open. I'm on Instagram, I'm on Twitter, I have Discord. You can actually comment on the back of the video if there's a way to get in touch with you. Also, I have an email listed on the channel. If you'd like to email it, that's fine. But I am very interested. I want to know more about that. Uh-huh. See, I sent her a reel at 7:05 and she reacted. Okay. You think it was in England? Can't remember the details. Okay, you know what? I'm gonna search a little. Kyle, help me out. Like, let's search a little bit on that. That sounds fascinating to me. I would think it would be a big deal. There must be headlines from somewhere. Okay. Juju said one time I did report to other neighbors that the nosy neighbors had a box in her yard. It was meant as a joke, but it was nosy of me. I don't blame you. It's easy to fake a live stream, really, but it's easily falsifiable too. How do you have to have interaction to prove it's alive. And now YouTube can, actually it's not. On YouTube, it's not because they differentiate between what is alive and what is upload. Okay. So what am I going to be doing? Playing a recording in front of the mic? I guess you're right. But still, there would be no chat interaction. And I think by pulling the chat interaction into the live, it could easily be debunked. Easily be debunked. Because you can't actually predict the live chat, can you? That's not there before. It was Stephen McCullough who faked a live stream as an alibi. Thank you, Tony. We're going to write that one down. I'm going to put it up here so anyone replaying later, if anything happens to the chat. It was Stephen McCullough. Is that from England too, Tony? Yeah. I'm going to look it up. You would have to become a channel that doesn't interact with chat. Exactly. And why do a live stream if you don't do that? Unless you're doing like a live action something or other, I guess. It was for murder, Mippet? Wow. Now I really want to look. You could feed pre-recorded video into a stream, kind of like when you do an intro or an outro. Yes, we could, but it wouldn't be interacting with the chat. And so that would be, I think it could be easily debunked. I really do. I really do, Rocket Couch. I do. I think it is. I think there would be plenty for the prosecution to go at if that was the defense. 4 different cases, Mippet? Okay, we got to talk now. Okay, we got to talk. Okay, so basically what I'm going to say is don't anybody try to use that as an alibi. It doesn't sound like it's very successful. And I'm laughing just because I can't believe that was the thing. Yes, they could debunk it, Yeah, I think they may be able to. But if you have an avatar like I am, you're not on screen, but even if you were on screen, what do I know? Yeah, there is probably a way to do it. I just think it could be debunked because of the interaction. Because whenever you pre-record something, you're not going to have the live reaction of the chat. So it's not going to match exactly. I mean, you could get some of your mods to do this, that, or the other thing. But then again, what's an alibi when you've got people out there that know you asked for something different and could actually give testimony against you? So you see what I mean? It could fall apart really quickly. You'd have to be a whole bunch of dummy accounts at the same time. And how are you going to be doing that while you're out there committing a murder? You're going to be like making a fake live chat at the same time? Like, well, there's just so many ways for it to go wrong. Yeah, so many ways. Yeah. And you're counting on no internet issues, making sure the cat didn't jump up on the keyboard. Can you imagine? Like, or any of that stuff, like the dog hitting the table and knocking everything over. Yeah. Yeah, there's like Record says, all you would have to do is just say your throat is sore so you can't talk the stream and it would be an easy yeah. Ha ha. Of course you figure a clever way to get rid of murderer. Okay. My favorite serial killer wannabe here. Yeah, I don't know if that's an easy out though. Yeah. I don't know. You need to be you need to be a super geek to pull it off, but it still leaves traces. I do think they could be debunked. I'm gonna stick with that. A good prosecution team, a good tech person could definitely debunk it, I'm pretty sure. But it's fascinating, and I'm glad we're all gonna end on a very intriguing note like that. I will be back tomorrow with more Trump law cases, probably earlier than tonight. Um, I don't know. Do you guys have a particular time that you prefer? If you do you want to put it in the chat or talk to me about it? My day tomorrow is pretty flexible, and I don't want to interfere with too much. I know our friend Mousy is hosting a live uh at 10 o'clock, I think, just hanging out watching the fish eat tonight if people just want to chat. If one of the mods want to put her link down there, that would be great. Or if you have the ability to right click on her name, you probably will be able to come up with her channel pretty quick. Some of the browser tabs allow you to do that. Yeah, you don't have to react to them. I get that, Brilliant. You know, they just play games and stuff. Yep, and that wouldn't hold up for me because it would be a different MO. Look at this. This is a true murder minion here. Okay. It wouldn't hold up for Claire though, because it would be a different MO on her stream. Exactly. If I wasn't interacting with you, that would be totally against what I normally do. And it would get like totally debunked right away. You're right. Yep. Absolutely. The current time actually works great for me. I get to catch it on the way home after work. I do like this time. Um, I would I just don't want to interfere with what anybody else is doing. I think I work with JL a lot. I think maybe his weekend horror is at the same time. So I want to go before or after. I turned around for 1 second, turned back around, and my cat is standing on my keyboard and the screen is blue. See? Like, don't try to do murder with your cat around. They will throw you in. Cats, I love cats. I had plenty, but when they want to be, they can really be assholes. Yep. Grace has no alibi. Yep. Yep. Silent. Oh, yeah. See that cheesy? Look at him. He's so guilty. Look at you. See that? The serial killer wannabe in the chat. I know. I know. Okay. So, okay. I'm going to check the time of other streamers, and if I can do it around this time, I will rock it. It might be a little bit earlier, a little bit later, but yeah. Mousy, there's going to be a chat. There's going to be a chat for her live stream watching the fish feed eat. Right? They don't eat each other, do they, Mouse? Like, I'm worried about that. I don't want to watch. It was Wrecker with a bow in his backyard. Yep, I'll go with that because that is like we see that often, don't we, Juju B? Like, yep, yep, we see that often. You know. Thank you, Mippet. Everybody, hit that like, hit the like, share the stream. Do all of that like lovely kind of stuff. It does help with the algorithm. You are helping me get a few of my other things out there, which I appreciate. Apparently we've been getting a lot of push on the Ryan Upchurch case. Basically quite a few of the members of his fans and friends came over to tell me that there is no case. And I just want to happily report that I did find it on Pacer. It's documented. It's signed by his own attorneys and just waiting on their response. It's filed. It's there. There is an active case. Exactly what I reported. But what I showed on screen didn't have the number on it. Because we were waiting for the actual file. But it is filed. It's done. I'll put the number on the back of the video for anybody who wants to go look it up. Of course, But I just thought that was amusing that he's out there saying that now. It's all fake. It's fake news, people. There's no suit against him. Nope. It's not him. Yep. Not him at all. All right. On that, I'm going to say goodnight. Thank you so much to my moderators. You make this very easy for me. I don't have to worry about any kind of shenanigans. And thank you to all of you in the chat who came forward to participate in the discussion. You make it much more interesting. And you make it worth doing all of this back and forth, because I want to do it with you. I want to share that conversation like I do with my friends privately. This is a hobby that I like. I'm not an expert. It's just opinion and commentary, and I'm glad that you're here to do it too, because your opinion and commentary on it and your questions help make it more interesting and give a broader perspective for everyone involved. Okay, so everybody have a good night. I will see you all tomorrow, and and I remembered my banners. I get a gold star for today. Thanks. Thank you, Mocking Media, for my fantastic intros and outros. And I'll see you guys all tomorrow. Oh, wait. I need to drop my link each time you say shenanigans. Yes, you can, Mrs. Cassandra. Mrs. Cassandra. Well, you're going to see me tomorrow, but Cassandra's shenanigans has something coming up on Thursday. Yes, and so do I. But tomorrow we can drop links too. You can drop them now. It's going to go for a little while. Anyone who has a channel, drop your link. It's cool. And if you want your link dropped more often, just let me know.